a little bit of a how not to get sued at the beginning. If I had like a hit list of things that I would ask lawyers not to do, these are the ones that, oftentimes end up in my lap.
It really starts to depend on what type of practice you have. Pick a good client with a good case who has reasonable expectations. If your client has unreasonable expectations, isn't pleasant to deal with, that you can just tell is going to be a problem, don't take it. So that's, I think, number one, easiest way to avoid getting sued.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm very excited to share this conversation with Marshall Cole. Marshall is a trial attorney at Nemechek & Cole, known for handling high-profile work with a particular focus in professional liability defense. He's the lawyer that you don't want to need. Marshall will share with us his insights from his years in the trenches on how not to get sued, what to do if it does happen, and other learnings along the way. Marshall has built an impressive track record of securing favorable verdicts for his clients. Beyond his professional practice, he contributes to his community as a volunteer prosecutor for the City of Inglewood. Marshall honed his competitive spirit well before becoming a lawyer. Marshall won the World Skiing Junior World Championships in 2001 and went on to represent the United States in 4 World Championships after. When not in the courtroom, Marshall works off stress on the bike, mountain bike, and ski slopes. Welcome to the show, Marshall.
Thanks for having me.
For those who don't know our background, we've done a number of presentations. Are we at 2?
We've done 2.
2, yeah.
2 with one on deck in a couple months.
On artificial intelligence. So it'll be interesting to talk about something different.
Indeed.
Kind of getting straight into your work. Tell us a little bit about the kind of practice that you have in terms of professional liability and other matters.
Sure. So, managing partner of a firm called Nemechek & Cole here in Los Angeles. And we are known for what I like to think is being the preeminent firm handling professional liability matters, and in particular, defending lawyers throughout the state of California. We handle accounting malpractice cases, directors and officers, as well as employment-related claims. But like I said, what we're really known for is defending lawyers, and I absolutely love what I do and getting to have lawyers as clients. It's just a real joy to have as my practice.
One of my notes is, in terms of doing background work, is you are the lawyer that we lawyers do not want to have to need. Is that a fair statement?
You don't want to have to need me, but when you do, you're sure glad I'm here along with my team, because it's a true specialty. I mean, I'm a certified legal malpractice specialist. We have more specialists at my firm, I think, and I'm pretty confident I can say this, than any other firm in the state of California. And, so we really know what we're doing when we handle these types of cases. And it makes a huge difference using us versus someone less experienced.
I definitely get into that a little bit more. Before we get there, though, I'd love to hear a little bit about how you found your way into the law and into this particular field of law.
Yeah, not sure how much of a choice I really had in my life as I was reflecting on that question. My father started the firm in 1984 with the other founding partner, Frank Nemechek. By no means were they doing professional liability matters back then in 84, but it was just the two of them, working away, getting cases, getting business, slowly growing the firm. And then my father kind of found himself starting to handle these types of cases for a particular insurance company, and just got more and more into it. And the practice evolved and grew to the point where, to his name and to the firm's name, we have well over 50 published decisions today, generally speaking, on issues that pertain to fee disputes, legal malpractice related cases, and other issues as well. But I do like to think that he really kind of pioneered this particular practice. And so when it came time for me to go to law school, which is something I knew I wanted to do and sort of follow in his footsteps, I certainly didn't have any idea that I would, later take over the firm after he retired. But after graduating law school, worked at a large firm in Century City for a while, and then he just kept pushing me to come over and come over and come over and get real experience. And after about a year, I did. And honestly, it was the best decision I ever made. A, just getting to learn this practice basically from day one. And it's really all I've done is defend lawyers. And so getting to try cases and defending lawyers and just getting that experience has really allowed me to be where I am today and have the confidence I have in representing, massive worldwide law firms down to mom and pop sole practitioners who would go and hang a shingle. So I don't know that I really ended up having a choice in the matter, but that's how I got here.
I presume you overlapped with your father for some time.
Yep.
What was it like to practice with your dad?
We overlapped for over 10 years. He retired about 2020 or 2021. It was amazing. We have very different personalities. For a lot of it, I was very young and inexperienced. So I was just working on cases and he was a couple levels above me. But as I got more experience and was trying cases, where we were more equal, we were great partners and collaborators on matters. And because his style was much more aggressive and intense, and mine's more laid back and smooth is the word I would use, but we were just very different. And so we worked well together. It was sort of that yin and yang. And also, it's kind of truly a family business. My mother ran the whole back office for us, which is now done by my sister. So we were really able to effectuate a transition when that time came up. But, it's just an enjoyable thing. Not often in a law firm do you get to have it be a generational thing. It's not like we manufacture a product that you can just sort of hand the keys over to. But at the same time, it had its challenges and difficulties. For a long time, he had these massive shoes that I said, how am I ever going to fill them? And so I realized once I started to get my own business and get my own results that I just was like, I'm never going to fill them. That's not something I'm interested in doing. I'm going to just put my own set of shoes right next to his. They'll grow as big as they can. And once I did that and just kind of established myself on my own, it made a huge difference for me professionally and personally, and just how I felt about myself and my career, and not so much sort of measuring it based on the success that he's had versus just focusing on, I'm going to do my thing and the results will come. And they have, since I've kind of shifted that my focus in that way.
I think you said something that's really important for younger lawyers to hear and process, because oftentimes younger lawyers they see other people, mentors, what have you, and they feel like they have to do things exactly the same way, as opposed to adapt to their own style. And it sounds like you did that, and I'd love for you to expand a little bit about how that worked for you.
Yeah, I think the best thing that mentors can do for you is teach you what you're not going to do. You see them do their thing and you can learn, that's not me. I'm not going to practice like that. I see why they do it and why it's effective for them. But I often see lawyers that if they feel a little uncomfortable, it's probably most likely because they're not being themselves. I mean, you have to, at the end of the day, be yourself and practice this profession because we provide a service. And so it's really, you're selling yourself. And if you're selling someone else disguised as yourself, it's just not going to work. And you're going to also kind of have a miserable career because you'll be uncomfortable the whole time or insecure about what's going on. And so I think he was a huge mentor for me in learning about the law and how to run a business, but also he's super intense and aggressive. And I said to myself, I don't want to be that guy. I can resolve cases or handle things with my own personality in a totally different way and get the same result. He probably would say, I can't do or couldn't do what Marshall did. There's just no way. He was too intense. And so I think it's a huge skill to learn when a young lawyer or a seasoned lawyer is being mentored by someone. I mean, I think the majority of my mentors probably didn't even know they mentored me. It's just, good being around good lawyers.
I'm going to push back a little bit on the intensity, and it's a tangent, but as I was doing my homework, I noted the bit on your water skiing background.
Yep.
And my impression, and I'm going to ask you to unpack that a little bit so that people understand what I'm referencing. My impression of somebody who has competed at that level is that that's somebody who also is going to be fairly intense and going to potentially want to be in a courtroom, type A personality. So with that as background, can you unpack that a little bit in terms of your competition background?
For basically age 6 to probably 25 or so, competed in a sport called water ski racing. This isn't slalom skiing or anything like that. This is getting behind a boat, putting a water ski on, and going at speeds of anywhere from 115 miles an hour down to 50 miles an hour, depending on the water conditions. And you ski and race for, depending on the type of race it is. The world championships were an hour-long race that you'd compete against people from all around the world. And when I was 17, I was the junior world champion, representing the United States. And then I subsequently competed on 3 more United States water ski racing teams representing the US in competing. So it's intense, definitely. I think to balance it with what I was saying earlier about my personality, I like to go fast. I've water ski raced at well over 100 miles an hour. I bike ride, as I know you do, and enjoy intense activities. I snow ski a lot now, which has really taken the place of water skiing for me. And maybe that's where I'm able to flex that muscle when I need to. And then when I come here, and mostly the intensity is just, when I interact with people, opposing counsel, we're litigators, we're dealing with that type A personalities, we're competitive, we want to win for our clients. It's more just when I do that in dealing with opposing counsel most often, I do it very nicely. It takes a lot for me to get angry. I always shake my head when I get an email from opposing counsel that's angry, or a lawyer that I deal with throughout the whole case that's just angry. And I'm like, I feel bad that guy or woman has to live in their own body. It's just like, it's just a case, and I enjoy it. And I try to, treat people with professionalism. And so that's where it's more my calm demeanor, I think, gets great results for clients, because I just cruise through the case. Not a lot's going to ruffle my feathers. Maybe again, it's because I have this outlet where I can go crazy and be super intense, that I don't need to do it here.
From there, I'd like to pivot into your focus and my thinking of approaching this, and totally open to input on how we tackle it, but kind of a little bit of a how not to get sued at the beginning. And what I mean by that is, are there patterns you've seen, ways that lawyers are handling themselves or their cases, where you're like, yeah, if I had like a hit list of things that I would ask lawyers not to do, these are the ones that, oftentimes end up in my lap?
I mean, it starts at the beginning, funny enough. Oftentimes I shake my head when I get these cases, client selection. So many cases that I get, the lawyer, the first thing is, I knew this client was going to be trouble when they came in the door. Well, then don't bring them in the door. If your spidey senses are tingling and all the red flags or bells and whistles are going off, send them on their way. Guess what? There's another case right behind it, And so I think it's poor decision-making and intake that leads to a lot of claims. And then you're stuck with defending a legal malpractice case and dealing with it for a year or two. That's the easiest way to avoid it. Pick a good client with a good case who has reasonable expectations. If your client has unreasonable expectations, isn't pleasant to deal with, that you can just tell is going to be a problem, don't take it. So that's, I think, number one, easiest way to avoid getting sued. From there, it really starts to depend on what type of practice you have. We represent personal injury lawyers, real estate transactional lawyers, a lot of family law lawyers, entertainment lawyers, and each one of those little practice groups carries with it certain issues that come up more than others. Like family lawyers, for instance, a lot of them are boutique firms, if not all of them, unless you're going to go to a really big firm and a super high net worth. They have a lot of cases, and they're already dealing with people who are generally going through the worst time of their life. So you're already dealing with that emotional level of, sadness, anger, all the bad emotions at the same time. And of course, you're trying to do work for them, get paid for that work, and get them out of it so they can move on. Unfortunately, I think a lot of them have a high volume practice, so things just fall through the cracks. And then they're just difficult people to please because of the situation. And so I've handled a lot of cases regarding child custody or, the financial arrangements that get it set up by way of settlement. And then, a year later, they say, oh my gosh, this deal was horrible. And they're easy enough to defend because it's tough, virtually impossible to prove that there would ever have been a better deal or a different deal that the husband or wife on the other side would have agreed to. But, that's just the nature of that practice in particular. And like I said, others carry along different types of things. I mean, personal injury, for instance, a lot of personal injury lawyers represent multiple clients at the same time. Passengers in a vehicle, the driver and a passenger in a vehicle, whatever it might be, you've got to watch out for conflicts. And when the new rules came out, which they're not new anymore. I mean, they're almost 5-7 years old at this point. Basically, anytime you have multiple representation, it's a potential conflict, and you need a conflict waiver. The older rule pre-2018 didn't have that. There was more leeway there, and so those are issues that come up on those types of cases. And again, settlements that fall below what people think were reasonable. One more easy way not to get sued is if you're billing your clients, don't get a crazy receivable, right? Manage your accounts payable. Many, many cases come in because a firm racks up $100,000, $200,000, $700,000 in unpaid legal fees. Guess what's coming your way? A legal malpractice complaint. Does it have merit? No, it does not. But it is leverage to negotiate down that unpaid receivable. And we see that all the time, and it's such an easy thing to avoid. And also, if you do find yourself in a situation where your client's not paying, wait more than 1 year from the date that you stop representing that client before you file a lawsuit. The reason I say that is because in order to sue a lawyer, there's a 1-year statute of limitations that benefits all lawyers in the state of California. It's a great statute of limitations. It's as short as it can get, other than if you're a governmental entity, and take advantage of that. If you file your complaint for unpaid legal fees within the year, you're going to get a cross complaint for legal malpractice. So at least wait the year. You're still going to get it as an affirmative defense and an answer, but that's a whole different thing. So that's just the easier way to deal with it.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. Moving past the how not to get sued, do you have thoughts, opinions on the type of insurance and aspects of insurance, errors and omissions policies that lawyers should think about in order to protect themselves so that they have both a war chest in terms of defending themselves, but also some decision-making process?
Have it. There's too many lawyers in the state of California that walk around uninsured. California does not require it, but that does not mean you should not have it. Because anytime I represent an uninsured lawyer, I say, all that money you saved in premiums for however many years you haven't had insurance, you're just going to hand it over to me. And you have exposure. So it's just the dumbest thing to do. Having the insurance really then comes down to what amount is adequately going to cover you. And that really depends on your practice. In the PI space, think about the amount of the last settlement, or the size of the settlement of the last case you had, or the last verdict you got. I represent lawyers who've gotten 10, 20, $50 million verdicts. Does that mean you need to have $50 million in insurance? No, but it certainly means you probably need to have more than 1 million. You might want to have 5 or 10 million. So, and same with family law lawyers or whatever it is. What is the size of the cases that you're handling? And use that as a barometer for making a determination as to how much coverage you need to have. If you have more than one lawyer, things change there as well. If you're with a bigger firm, there's other companies that offer different things that can be beneficial to you. If you're over 35 lawyers, there's an insurance company called Alas. That's a great company to be with. There's Lawyers Mutual Insurance Company, which is Rights statewide, is a great company to work for, be insured through, because all of their claims professionals are attorneys, just like with Alas. And that makes a huge difference because they're lawyers and they all had experience in what we do before they went into that side of the practice, but they just know how to ask the right questions. They know how to evaluate a claim appropriately. So when it comes time to resolving it, you don't just have a claims adjuster out of state dealing with your issue. You've got someone here in the state of California. And so they're just a great company to work for. But depending on the amount you need, they may not be suitable. And then obviously price. You've got to weigh all these factors. But I do think you get what you pay for. So if you pay a little bit more, but the company's going to provide you a better service down the line. Of course, everyone thinks they're never going to get sued, and every client who I haven't represented for calls me, says, this is the first time this has happened in 43 years. My response to that is, it's the cost of doing business. Okay. Getting sued is the cost of doing business. It's not a reflection on you as a person, you as a lawyer, anything. It's just going to happen. So you've got to weigh all those different things and what you want. Some people just say they want the cheapest. Okay. There's companies that are clearly going to be cheaper than others. You're going to get the same amount of coverage, but if there's a claim, certain carriers handle things very differently than others. And there's a lot of great nationwide carriers out there that don't have people in the state of California. So I kind of use Lawyers Mutual as an easy example because they are here and you get that benefit. But there's plenty of larger companies that write for lawyers nationwide, and they bring different things to the table.
There are a couple other things that I've seen in policies over the years that seem to be things that you can, choose to pay more for if you'd like. And those are things like a consent clause, meaning it requires your consent to resolve the case. Things like attorney selection, meaning you have a right to say, within a panel or within a price range, you have a right to pick your attorney. And burning limits.
Yeah, every LPL policy is a consent policy. So lawyers, you have the absolute right to consent or not to a settlement. We can get into a whole conversation about hammer clause and things like that, but just know you have the right to consent. And they all burn. So no matter if you start with $1 million, if you go all the way to trial, you might have 200,000 left, depending on how litigious the case is. And then any excess is going to be on the insured lawyer if there's a verdict. So you've got to understand that when you're choosing your amount. And also there's things to look for. A lot of carriers offer a no deductible $25,000 or $50,000 reimbursement policy for state bar matters. So if you get referred to the state bar, which is just skyrocketing, the amount of state bar matters that my firm's handling over the last 24 months has gone up 10x at least. I mean, it's a really growing part of our practice because a lot of people are reporting lawyers to the state bar, and the state bar is following up on every single one of them. So it's a nice thing to look for is one of those reimbursement policies. And some of them will only handle formal proceedings. Some of them will only handle pre-formal proceedings. So you just got to read the fine print. And those are great to have. And then as far as selection of counsel goes, depending on the carrier, They generally have a panel. My firm does business with virtually all of the carriers. And if we're not on panel and you want to use us, generally speaking, the carrier will be amenable, given, if they look at our website or my bio, they can see this is all we do. But even before that, when you get insurance, you can make a request to write Nemesek and Cole into your policy. So it's clear just up front, look, if there's something happens, Nemesek and Cole is representing me. This is how it's going to go. And we're written into dozens and dozens of firms' policies throughout the state, just to make it that much easier. And because it's competitive, lawyers can get good pricing. You can get a good product that suits your needs, and you should be able to get what you want when something happens, which is the firm that you want to handle it for you. It's a great question that most people probably don't think about because they don't think it's ever going to happen to them. But if you're doing your due diligence on the front end, when it does happen, because it will, you've got everything, all your boxes checked, and then you come to my door and I say to all my clients, I'm only going to bother you if I need you. Go do your work, go make your money, go be a lawyer. This is why you have insurance. You're with us. You're in good hands. And I think if you're with a firm with less experience, you're going to feel that.
Your comment about people coming in either without coverage or not the right coverage. I think of the number of times I've had potential clients come in where they have like a very low underinsured motorist coverage. Mm-hmm. And you have this conversation with them of like, yeah, well, you went cheap. And unfortunately it's come home to roost. It's interesting how, while we say that to a lot of our clients, a lot of us don't have that shift in our brain. We do the exact same thing when we're looking at our premiums that our clients are doing when they have that low UIM.
Yeah. And I mean, California, you can get $100,000 policy as a lawyer. I've never had one for less. And I've got a couple of those cases and I say, what are you going to do with this? And those burn, so it's maybe some of them will have an expense reserve of up maybe 50 grand before it'll burn, depending on the company. So you have that benefit, but in this day and age, $100,000 in a legal malpractice case, you can't defend it. And so you better hope almost that they take the 100, unless it's just a really small case, because otherwise you're facing excess exposure from day one.
You put out two things that I want to follow up on, and one was hammer clause, and the other was the increase in state bar discipline proceedings. And I know they're very. I'm putting a pin in one of them. Which one is the natural path, do you think, for our conversation now?
State bar proceedings, I think.
Okay, you said that you're seeing a lot more of those. I imagine they're a little bit different in terms of the handling and what, if somebody receives something like that, what they should do. And do you have any best practices? You get a letter, we've gotten a complaint. What should that lawyer do?
It's a scary letter to get because on the very front page of the letter in big font, it says your state bar license is at risk. So it's not like a warm and fuzzy letter that you get. The first thing you should do is go to someone who handles these types of things. It's going to cost you money, but our firm specializes in this. We have myself, Ellen Pansky's with our firm. She exclusively handles state bar matters. Just like using us for legal malpractice cases, you want to use a specialist. The thing I see a lot is lawyers think they can just handle it on their own. And maybe they can. But is that the best thing to do? Not necessarily, because we work with these investigators. We work with the Office of Chief Trial Counsel. So, these people, and that makes a difference down the line as far as how things go, getting certain extensions, teeing things up appropriately to try and get it resolved before formal charges are brought. So and oftentimes we step in the second round of letters, right? Because the lawyers tried to do it themselves on the first round, and that didn't go so well because maybe it's a trust accounting issue and they're going to try and not turn over their trust account documents or handle it in a different way or spin it in a certain way. And depending on the questions they're asking, just putting your cards on the table and explaining what went down is the best way to get it resolved.
I want to now return to hammer clause, and while we may be out of sequence in terms of how one handles a case, it's a cool phrase. I need the answer to what it means to you in your world, and when you said one can have a lengthy discussion on it, what is it and how is it used?
If you as the lawyer are, let's say you've got a $2 million policy and there's a settlement offer for $1 million, and you refuse to consent to that settlement offer that's made, essentially if you as the insured decline a reasonable settlement and the case goes to trial, the insurer's responsibility for covering any additional costs can be reduced or potentially eliminated. And so those are potentially, they're in a lot of professional liability policies. And so while you can consent and not consent to a settlement, you need to be aware that if you don't consent and the carrier is saying, look, you need to settle this case, they can invoke that clause, and then the lawyer's taking on a little bit more risk. I have never actually seen that play out through a trial where that has occurred. I've definitely been in a lot of heated discussions between the insured and the carrier, because my job is I deal with the tripartite relationship. I vigorously defend the insured, but I also have a fiduciary duty that I owe to the carrier to objectively advise them about their potential exposure. But I'm not going to get involved with fighting over whether someone should consent to settle or not. It's their decision, and the carrier is going to do what they're going to do. And I'm just going to continue to defend the case the same way, and often do talk about the positives and negatives. And at the end of the day, the insured has come around and resolved the case because that's just the right thing to do. I mean, I think you have insurance for a reason. Let it protect you. Oftentimes I get calls from clients who say, I don't want to tender this. I don't want to tender this. It's going to go away. And I say, tender it. You have insurance for a reason. Everyone worries about their premiums going up. And I understand all these things, but you're paying for something, use it. And if something resolves very early for no money or little money, it's not going to have some big impact unless it's your fourth, fifth, or sixth claim.
There's the flip side of the hammer clause is the scenario where there's a settlement offer, the insured is like, hey, get me out. And the carrier is reluctant. In that tripartite relationship, what position do you have and how do you handle that?
So when that happens, it just depends on my analysis. And, why I think a lot of insurance companies like working with us, just like lawyers working with us, is I don't put shade on things. I call it like I see it. Everyone in my firm does. We objectively analyze a case. Just because a lawyer wants to resolve it and move on and doesn't want it hanging over their head is not a reason to pay money. And so when that happens, obviously the carrier has to make an informed decision based on the analysis that we prepare. And if the carrier says, look, Mr. or Mrs. Lawyer, I'm not going to settle this case, we're going to proceed based on the analysis, then we proceed. And it can, then you can sort of bring up counsel related issues, and they're obviously down the line. Bad faith can come into play if there was an adverse verdict, but we analyze the case objectively. And so we go through a detailed ongoing process of creating an initial litigation report and plan, and then updating that every 30, 60, 90 days as things change. So, case might be one way on day one, and on day 400, completely different, and changed all along the way in between those 2 points in time. So, it's our job to just be objective advocates for the case itself. And I've been in that situation a number of times. And again, they generally resolve. and it just might take a little bit more time to get the carrier there or get to a right number. But it is a scenario we find ourselves in.
The lawyers who handle these cases on the plaintiff side, do you find that it's small pond, a lot of repeat players, or are you frequently running into new and different fish?
Small pond. There's some great plaintiffs lawyers out there who we deal with regularly, and then there's one-offs like anything, and obviously we know who we're dealing with, and so if we're dealing with a repeat player, and just because they're a repeat player doesn't mean they're good, but there are very good ones, and we know what we're dealing with, and that plays a role in how we deal with the case. I mean, that makes its way into a litigation plan. And if you're not putting that in or evaluating that on either side of the aisle in whatever your practice area is, that's crazy. Because who your opposing counsel is one of the most important things about a case. If I'm dealing with someone I've never heard of, and we'll do research and look into cases they've handled, and if they don't mention that they handle professional liability on their website, I know what I'm dealing with. So I know a summary judgment motion might be a little easier on this particular case because they don't necessarily know the case law or the issues that are going to come up, versus one of my colleagues who I deal with routinely, where I say this is going to be a tough one because A, they only take good cases, B, they're very good lawyers, and they know how to try a case. So you've got to approach it with that in mind.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have for who you'd like to see on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.